The marble columns of Supreme Court's courtroom 3 loomed behind Denzel Washington as he stood at the lectern, his Navy suit impeccable, his demeanor unshakable. Moments earlier, Chief Justice John Roberts had delivered a stunning rebuke. Mr. Washington, I find it difficult to believe that someone from your background fully understands the constitutional implications of your position. The packed courtroom erupted in murmurs. Law clerks exchanged startled glances, veteran attorneys sat upright, and journalists scribbled frantically, sensing a historic moment unfolding. Washington, the Oscar-winning actor who had secretly earned a law degree from Howard University while starring in blockbusters, didn't flinch. His calm presence belied the weight of the moment. Roberts, a Harvard-trained legal giant with 16 years leading the nation's highest court, believed he could expose Washington as a celebrity out of his depth. But Washington, armed with a novel constitutional theory and a mastery of case law that would astonish the court, was about to transform this condescending challenge into one of the most memorable oral arguments in Supreme Court history. This was no ordinary hearing. It was Washington's opportunity to prove that brilliance can emerge from unexpected places, challenging preconceptions and potentially reshaping American constitutional law. The case, Henderson versus Department of Justice, centered on civil forfeiture laws that disproportionately harm minority communities. The government had seized a community center and surrounding properties in a predominantly black Philadelphia neighborhood, citing a single drug transaction on a nearby sidewalk. No property owners were charged with crimes, yet millions in real estate were taken through civil forfeiture. Washington's amicus brief, initially dismissed as celebrity activism, proposed a groundbreaking reinterpretation of the Fifth Amendment's takings clause. Challenging decades of legal precedent. 3 months earlier, Washington's name on the case docket had sparked skepticism. Legal circles assumed his involvement was a publicity stunt, unaware that he had earned a J.D. from Howard University School of Law, studying nights and weekends between film projects while keeping his academic pursuits private. His 40-page brief, however, revealed a sophisticated argument. The Fifth Amendment's requirement that private property not be taken without just compensation and public use imposed stricter limits on civil forfeiture than modern practices allowed. If Washington prevailed, the ruling could curb government power to seize property without criminal convictions. If he failed, his legal theories, developed through years of rigorous study, risked being dismissed as the musings of a dilettante. Chief Justice Roberts, 67, presided with the authority of a sterling career. Harvard Law Review, clerk to Justice Rehnquist, principal deputy solicitor general, and nearly 2 decades on the Supreme Court. Known for incisive questioning and sharp hypotheticals that expose weak arguments, Roberts saw Washington's 10-minute oral argument slot, rare for an amicus brief, as a chance to test the actor's legal mettle. Many in the courtroom shared his skepticism. "This isn't Hollywood," a corporate attorney whispered in the gallery. "You can't memorize lines and expect to sway the Supreme Court." As Washington approached the podium, his quiet confidence stood out. Unlike many first-time advocates who appeared nervous, he moved with the poise of someone accustomed to high-stakes performances. "Mr. Chief Justice, and may it please the court," he began, his resonant voice filling the chamber. "The Fifth Amendment's provision that private property shall not be taken for public use without just compensation was understood by the founders to require not only monetary payment, but also a genuine public purpose and procedural protections before the government's power could be deployed against a citizen's property." His opening was eloquent but conventional. Roberts, who had skimmed Washington's brief with skepticism, saw an opportunity to challenge what he assumed was a superficial grasp of the law. Breaking protocol, he interrupted just 40 seconds in, his tone tinged with condescension. "Mr. Washington, while I appreciate your interest, I find it difficult to believe that someone from your background fully understands the constitutional implications of your position. Your brief overlooks 2 centuries of settled forfeiture doctrine." A murmur swept the courtroom at the unusually personal jab. Justice Sonia Sotomayor shifted uncomfortably, and Justice Elena Kagan frowned slightly. Washington paused, meeting Roberts' gaze with a calm that those familiar with his acting recognized as the prelude to a commanding performance. "Chief Justice Roberts," he replied evenly, "I believe my argument aligns with the historical understanding of the Fifth Amendment, as articulated by Justice Thomas in his concurrence in Timms versus Indiana. Perhaps we should examine the textual and historical evidence together." He opened a well-worn copy of the Constitution and a folder of original sources, a rare move for an advocate. His methodical preparation caught Roberts off guard. This was not the celebrity posturing the Chief Justice had anticipated. What followed was a legal chess match that would leave the court and the nation stunned. Roberts, realizing his initial dismissal hadn't rattled Washington, pressed harder, citing the Palmyra, 1827, a landmark forfeiture case. Your brief argues that civil forfeiture was limited to admiralty and customs cases, but the Palmyra clearly established broader government powers, he said, setting a trap that had ensnared many seasoned attorneys. Washington responded without hesitation, flipping to page 23 of his brief. With respect, Chief Justice, I addressed the Palmyra in detail. Justice Story's opinion applied to a maritime piracy case, where the vessel was treated as the offender due to jurisdictional challenges. This fiction made sense in admiralty law, but Story never suggested it should extend to domestic seizures from citizens within the court's reach. He continued, his voice steady but forceful. I've traced every civil forfeiture case from 1789 to 1850, all 27 of them. Each involved maritime seizures, customs violations, or piracy. Not one approved a land-based seizure of property from innocent owners, as we see in Henderson. The courtroom fell silent. Washington's historical analysis was not just thorough, it was unprecedented. Few scholars, let alone practicing attorneys, had conducted such a comprehensive review. Justice Samuel Alito, often sympathetic to law enforcement, interjected, "That's an interesting historical point, Mr. Washington, but what about modern precedents?" In Bennett v. Michigan, 1996, this court upheld forfeiture from an innocent owner. Washington didn't waver. Justice Alito, I believe Bennett was wrongly decided, as Justices Thomas and Ginsburg argued in their dissent. It created tension with Austin v. United States, 1993, which held that forfeiture is subject to the Eighth Amendment's excessive fines clause, and Timms v. Indiana, 2019, which applied that protection to the states. These cases recognize forfeiture's quasi-criminal nature, demanding constitutional limits. Gasps rippled to the gallery at his bold challenge to precedent, but several justices took notes, visibly engaged. Justice Brett Kavanaugh raised a practical concern. Civil forfeiture is a critical tool for law enforcement. Are you suggesting we eliminate it entirely? Washington shook his head. Not at all, Justice Kavanaugh. I propose restoring forfeiture to its historical boundaries, appropriate for admiralty, customs, or unclaimed property, but not for seizing homes or businesses without criminal convictions or clear evidence of owner complicity. Roberts, still probing, questioned the obscurity of Washington's founding-era state court cases. How can we be confident these represent mainstream views rather than outliers? It was a question designed to expose shallow research. Washington smiled faintly, seizing the opening. Far from outliers, Chief Justice, these cases reflect a consistent pattern across jurisdictions. From memory, he outlined the facts and holdings of 8 state Supreme Court decisions from the early Republic, demonstrating a narrow understanding of legitimate seizures. His command of primary sources was staggering. Justice Kagan, visibly impressed, interjected, Mr. Washington, your historical research is remarkable. Did you work with a team of legal historians? For the first time, Washington showed a hint of pride. No, Justice Kagan. I conducted the primary research myself, tracing cases through archives during my studies at Howard and in the years since. A buzz ran through the courtroom as spectators realized his legal credentials were genuine. Justice Sotomayor refocused on the case. How would your framework apply to the community center seize in Henderson? Washington turned to her. Justice Sotomayor, the seizure fails on multiple grounds. First, a single drug transaction on a public sidewalk creates only a tenuous link to the property. Second, the government hasn't proven the owners knew of illegal activity. Third, seizing property for general funds violates the Fifth Amendment's public use requirement, as the founders understood it. His clarity and conviction resonated as Washington's allotted 10 minutes stretched. Court officers discreetly allowed him to continue, a rare courtesy signaling the justice's engagement. Roberts, now fully attentive, posed a final question. If we accept your framework, what test would you propose for future forfeiture cases? It was an invitation typically reserved for elite advocates, a sign of the court's respect. Washington didn't hesitate. Chief Justice, I propose a three-part test rooted in the Constitution and recent jurisprudence. First, the government must prove a substantial connection between the property and criminal activity. Second, where owners are subject to jurisdiction, due process requires a criminal conviction or clear evidence of their knowledge and consent to illegal use. Third, the forfeiture must serve a specific public use, not merely generate revenue. He concluded with quiet authority. This approach honors the Constitution, aligns with history, and protects innocent Americans from government overreach. A profound silence followed. Several justices were still writing. Others processing the argument's depth. Roberts, his earlier condescension replaced by respect, said, "Thank you, Mr. Washington. Your argument has been exceptionally informative." The acknowledgement carried weight. An admission that his attempt to challenge Washington had revealed a legal mind of extraordinary caliber. S. Washington returned to his seat. The government's attorney approached the podium, visibly rattled. The case's dynamic had shifted. What began as a routine defense of forfeiture powers now faced a formidable constitutional framework that resonated across the bench. The Washington argument became an instant sensation. Within hours, legal scholars were dissecting it originalist rigor, and social media exploded with clips of Washington citing Madison's letters and reciting early case law from memory. A New York Times feature revealed his academic journey. Graduating with honors from Howard, studying while maintaining his acting career, and anonymously funding scholarships for underrepresented law students. His professors described him as a dedicated scholar with a passion for constitutional history and justice reform. 6 weeks later, the Supreme Court issued a 7-2 decision in Henderson versus Department of Justice, ruling for petitioners and adopting much of Washington's framework. Chief Justice Roberts, writing the majority opinion, quoted Washington's argument 4 times, including his 3-part test. Civil forfeiture, as currently practiced, has expanded beyond its historical boundaries. Roberts wrote, "The Constitution does not permit seizures from innocent owners based on tenuous connections to alleged wrongdoing, particularly where community institutions are at stake." A footnote praised Washington's exceptional historical research. Justice Thomas's concurrence called for a broader re-examination of forfeiture doctrine, while Justice Sotomayor's emphasized the harm to marginalized communities, citing Washington statistics. In a rare personal note, Roberts concluded, "This case reminds us that legal wisdom can come from unexpected sources, strengthening our system when diverse perspectives are heard." The decision's impact was swift. States reformed forfeiture laws, and millions in property were returned to innocent owners. Law enforcement shifted focus to forfeitures tied to convictions. Washington launched the Washington Justice Initiative, a nonprofit aiding communities affected by forfeiture, and delivered guest lectures at law schools. 6 months later, Washington and Roberts appeared together at a Georgetown law forum. Their discussion, marked by mutual respect, reflected on their courtroom encounter. Roberts admitted, "Mr. Washington taught me never to confuse celebrity with capability." Washington replied, "The law rewards arguments on their merits, not the messenger." The story of a Hollywood icon humbling the Chief Justice through scholarly excellence became a modern parable. It inspired a 34% surge in law school applications from underrepresented minorities, with many citing Washington's example. In classrooms and courtrooms, his argument symbolized the power of preparation, perseverance, and the courage to challenge assumptions, proving that ideas, not identity, define legal excellence.